Hey everybody, we are on to Mr. Ficker's favorite topic, civil liberties. These are referred to the rights that you get in the Bill of Rights. So we're going to be talking about these, and you're going to be looking at stuff and reading and so forth about this for the next couple of weeks. So civil liberties, first of all, I want to go through the difference between civil liberties and civil rights. Okay, civil liberties are, like I said, the rights you get from the first 10 amendments. It's basically how the government must treat you. For instance, if somebody is at a protest, the government cannot take away somebody's right to free speech. If the government arrests somebody, if the police arrest somebody, they have to treat everybody the same. They get a hearing, they can get a lawyer appointed to them, they can have a trial by jury. Those are all civil liberties. That's how the government has to treat people. Civil rights are how the law must treat people. So, for instance, everybody has the right to vote. That is a civil right that people have. The segregation era, when there were Jim Crow laws, you learned about those last year, that violated people's civil rights because the law treated them differently. Okay, we'll do more about civil rights in a couple of weeks. Okay, so civil liberties, how the government must treat people. There was only a couple of things in the original Constitution. Most civil liberties you get from the federal government come with the Bill of Rights. And the reason there weren't many in the original Constitution is because most of the states already had their Constitution written in 1789, and they already had these rights, free speech, freedom of religion, and so forth, already encoded in their state constitution. So the people that wrote the Constitution said we really don't need those in the new Constitution because they're already in the state constitution. So, but that changed with the Bill of Rights. So anyway, the first few things that are listed in the original Constitution concerning civil liberties, first is habeas corpus. Habeas corpus can't be suspended unless we are being invaded by another country. Habeas corpus strictly means, it's a Latin term, it means that whenever somebody is arrested, their person, their corpus, has to be presented before a judge. And that's usually within 48 hours. If somebody has been arrested by the police, they have a hearing in court. And in that hearing, the state, the prosecutor usually says, this is this person's name before the judge, and this is the crime that they're accused of committing. And the accused then can say, I'm guilty or not guilty, and can request a trial at that point. Okay? That's habeas corpus. That cannot be suspended under the Constitution. Lincoln tried it in the Civil War, and the Supreme Court said unconstitutional because we weren't invaded by a foreign nation. Okay? Ex post facto laws, those are also banned under the Constitution. Ex post facto laws, it's kind of strange, but what they do is they punish people retroactively. So the example I always like to use is, most of our busy streets around school, the speed limit's 35 miles an hour. Okay? What if they changed it to 25 miles an hour tomorrow, and then the police arrested you for driving 35 yesterday? I know that sounds backwards, but bear with me. So when you drove on the road, it was 35. You were doing the law. But then they change the law the next day, and then they arrest you the next day or give you a ticket at least, for driving 35, even though it was 35, but now the law says 25. So that is an ex post facto law. That's a retroactive punishment. Retroactive refers to it wasn't a crime when you committed, when you broke the speed limit. Okay? And then, as you know, almost immediately the Bill of Rights were added to the Constitution, the first 10 amendments. And then a big change was the 14th Amendment. The 14th Amendment defined citizenship, and you probably know this. If you're born in the United States, you're automatically a citizen of the United States. But it also had something called the Due Process Clause and the Equal Protection Clause. And it said in there that states have to start following due process, treating everybody the same, and equal protection of the laws. The laws have to be, everybody has to be treated fairly the same by the laws. Okay, that's civil liberties and civil rights. And the 14th Amendment was defined as saying that the courts have said this over time, the Supreme Court, that these Bill of Rights has to apply. The states have to follow this. All governments have to follow them, because the original wording of the Constitution, or I'm sorry, the original wording of the First Amendment, for example, says Congress shall make no law abridging your freedom of speech. Well, that only applies to Congress. Well, could a state take away your free speech? Well, not after the 14th Amendment was passed, because the 14th Amendment said states have to follow equal protection and due process. Okay? By the way, the courts didn't like do a big Jedi mind trick, a big wave of their arm and say, all of these rights apply to the states. All the Bill of Rights apply to the states. People had to bring cases one by one and say, hey, this state law violates my freedom of speech. And then the Supreme Court of the United States would agree with them. Then the states would have to follow freedom of speech. Then in another case, somebody would say, hey, this state law violates my freedom of religion. And the courts would have to agree with them. And then the freedom of religion would apply to the states. Okay, that whole thing is called selective incorporation. Okay, so selective incorporation is after the 14th Amendment was passed. Don't worry about substantive and procedural due process. We're gonna skip that. Okay, 14th Amendment guaranteed that all citizens had to be treated equally. That includes the federal government and the state government. Okay, and in 1925, the first time the Supreme Court did this selective incorporation that we were talking about. A New York law said it was illegal to print and to hand out what they called subversive material that was against the government of the United States. Okay, this Gitlow guy was arrested under that, and he said his defense was, at least his lawyer put together the defense that said, hey, wait a minute, the 14th Amendment and the First Amendment apply in this case, because the First Amendment says my freedom of speech can't be taken away, and the 14th Amendment said states have to follow freedom of speech. So New York isn't following freedom of speech by passing this law that takes away my ability to speak out against the government. By the way, this is the over here on the left is the thing that Gitlow was handing out, what he published. Okay, and the Supreme Court of the United States said, Mr. Gitlow, you win. You cannot be arrested under this law because that law violates the Constitution's First Amendment freedom of speech, and that started this thing called selective incorporation. Okay, this is a chart from your book, and this goes through how it goes through all the amendments and says that all of them, minus the Third Amendment, no quartering of soldiers, that's never been applied to the states. Second Amendment has, the Fourth Amendment, Fifth Amendment, and so on and so on. And then this is incorrect because it says the Second Amendment hasn't applied to the states. There was, I'll get to that in just a second, but it was a case called McDonald versus Chicago that applied the Second Amendment to the states. And the right to trial in jury cases, right to jury trial in civil cases has not been incorporated because every state already has that right in there. So that case has never come up. A civil case is when somebody sues somebody else, which is different from a criminal case. A criminal case is somebody broke a law and they can serve jail time. Okay, every state has the right to trial in a civil case. So that has never come up before the Supreme Court. Okay, all the rest of them, -3 and -7, even 2, have been applied to the states. Okay, this Second Amendment one, McDonald versus Chicago, is a case where this guy McDonald lived in a neighborhood in Chicago. He lived in the city of Chicago. Chicago banned handguns to bring down crime. He wanted to own a handgun to protect his home, and he wasn't allowed to have that. And he sued, saying Chicago's ban on handguns violated his Second Amendment right to bear arms, and he won that case in 2010. Okay, now the First Amendment. There are 5 parts of the First Amendment: speech, press, religion, assembly, and the right to petition the government. We're going to spend a lot of time on speech and some time on religion and a little bit on assembly. Okay, but those are your rights you get from the First Amendment. Okay, freedom of speech, very clear. Congress shall make no law abridging the freedom of speech. Okay, now when you look at some of these cases, you probably notice the difference between pure speech and symbolic speech. Okay, pure speech is, using your words. Symbolic speech would be not saying anything, but making a statement using your speech, but saying something without using words. The armband case with the students in Des Moines, Iowa. Okay, they were using symbolic speech there. They weren't saying anything, but with their mouths, but they actually were saying something with these symbols. Okay, is this an absolute right? The answer is no. None of your rights in the Constitution are absolute. There are times when you can say, I am exercising my right to free speech, but it can be legally taken away. For instance, if any speech endangers public safety, if we get together and say, all right, here's how we're going to overthrow the government of the United States or the government of Coleraine Township, and I hand everybody a gun and say, let's go down to the township administration building, we're endangering public safety. We cannot use free speech as our defense. Okay, if you advocate anything that's illegal, that is never, by your speech, that is never upheld as protected speech. Protected speech means that it can't be taken away. So this is unprotected speech. If you advocate illegal activity, that is speech that is not protected under the First Amendment. Okay. Okay. When can it be regulated? So this is what regulated means. The difference between not protected, can be taken away legally, or when it can be regulated. Regulated means there are times when it depends on the circumstances. Okay, flag burning in a protest. That was made legal by a case called Texas versus Johnson. Okay, if you're doing it as part of a political protest and you're burning the American flag, as vile and unpatriotic as people might think that is something that is protected under the free speech, under the First Amendment. Okay, burning your draft card. In the Vietnam War, they gave out draft cards to young men with numbers on them. If you burned your draft card in an anti-war protest, that's actually government property that you were burning, and that was not upheld as free speech because the court said you can get your point across without burning your draft card. You can still protest the war without burning your draft card. Picketing a private residence. If I decide to go to the governor of Ohio, Governor DeWine, if I go to his private home and start picketing him there, that is not protected under the First Amendment. That is not protected First Amendment speech. If I went to the state capitol, that's a different story because that's not a private residence. Okay, that's public property. Now, I'm not going to worry about that test. Unprotected speech. This is never ever. The courts have always said this is not free speech. Sedition. If you urge resistance to lawful authority, or if you, if the police are arresting somebody and you're telling that person, hey, turn around and punch the cops or something like that, that's not free speech. If you advocate overthrow of the government, especially violent overthrow of the government. I don't know if you saw the case. There were several people arrested in Ohio for they were going to kidnap I'm not making this up, kidnap the governor of Michigan and put her on trial and overthrow the government of Michigan. Okay, that is not, you can look that up if you don't believe me, but that is something that is not protected speech. Any kind of defamatory speech that takes, that defames somebody. What am I looking for here? If you harm their reputation, okay, that's not protected speech. False speech that basically are lies. Any kind of speech that damages somebody's character or reputation, okay, that's called slander. Okay, written form is libel. Those are not protected under the First Amendment unless the person is a public official. You are allowed to lie about the President of the United States. The President of the United States is a public official, or the governor of Ohio, or the mayor of the city of Cincinnati. And that is protected speech as long as they're a public official. Okay? A private citizen, no. Okay? Obscenity, whatever that means, okay, you can look that up. Obscenity, it depends on the part of the country you're in. I think we have a different version of, in the Midwest, of what is obscene versus somebody who lives in California or New York City. But obscenity is never protected under the First Amendment. And then fighting words. words, if you say something to somebody and they punch you in the face that causes them to have a violent reaction against you, that is not